Lakewood?
Yes.
I've been talking to my attorney.
Hi, Mr. Landis.
Hello, you've been in contact with my attorney? I haven't spoken to my attorney yet. No, I don't have any paperwork from you.
All right, we're going to go into a
Stop talking for a moment, please, and we're going to get you into a breakout room, but you need to use, do you have the ability to use the mouse to join the breakout room?
Room 1?
Nope. The officer's going to help you, and then you're going to have a chance to talk to your attorney. Back on the record on Jeremiah John Landis.
Yes, Your Honor. So I would like to raise some competency concerns and file a 1077. I'll just need a minute to complete that. I've only done one, and so I just need a minute.
Okay, that's fine. Hi there, officer. We're going to be submitting a competency eval, and so that will come through, and then you can give Mr. Landis a copy of that once that's completed. But you're welcome to take him if you want to.
Yes, ma'am. Thank you.
Thank you.
Thank you.
Yeah,
You're welcome, sir. Thank you.
Well, thank you.
I had a feeling he wanted out of there. And that doesn't feel right to just make him sit there while we fill out paperwork.
All right, let's take up Danny.
All right. Hello. Nice to see y'all back in Chicago where the Wi-Fi usually works. It's good stuff. This one, Zach helped me out. I got a tip on it from Looking for Since Lair, and Zach helped me with some other clips. I got a lot of updates. This is an update. This guy was in court. He was in bed, and his wife was spewing self-sit nonsense to the judge. But here we are again. Frankly, I think he's a big liar about everything, but let's do this, shall we?
Lewis Johnson will be on the record in 2024 TR22 and 2024 TR541. Paul E. Dean for the state. Danny Johnson, are you present?
He is not present, Your Honor, and I have a note.
I think he's on the phone.
Oh, he is? Okay.
Now that I think about it, Mitzi, you said he is in.
I got an email.
Custody. Go ahead.
Yeah, I think so. I got an email from somebody at Leavenworth.
Yes, he is being held by, currently held for a court martial and is not going to be released until the court martial is completed. Therefore, at this point in time, Your Honor, I would ask that we issue bench warrants in both of the cases that are before this court with Danny Johnson, authorizing no bond.
He was ordered to be present in the courthouse today.
I am here.
He is here on the phone.
Well, that's on the phone is not in person at the courthouse, and he is in custody. So I need to issue warrants to keep holds on him. Mr. Johnson, is that you that I'm speaking to?
Yes, I was in the midst, got cleared by the doctor to come back, and when I came back, they apprehended me and said I was a deserter because I waited till the doctor to release me to come back. I was prepared to come there.
Sir, I'd recommend you not to be making statements in regards to a pending criminal court martial.
Well, I'm not worried about that, but at the end of the day, like I said,
Well, hold on, please, sir. Okay, so Mr. Johnson, you and your wife at the last hearing asked that this matter be set for bench trial today, and we are set. We are set for bench trial, but then I've also seen you have filed motions for jury trials. I've seen that you've filed a motion to recuse me as the judge. And I show that your wife has filed a motion against me with the judge's disciplinary board. So
I can't answer for what she did or what someone else did, but in reference to myself, I did file those motions, and I also prepared to be at court. Unfortunately for me, like when the doctor cleared me to come back, I came back, and then they said I was a deserter. So they
All
couldn't
right. Well, I'm not
find
going
me
to
for
get
that.
into your military court.
I'm not asking you. I'm just giving you the reason
Okay.
why I'm not
All right.
there.
And I appreciate that. But from the beginning of these proceedings, you've insisted you did not want an attorney. I think I've even tried to strongly encourage you to consider an attorney, but are you still of the position that you do not want an attorney, that you want to proceed on your own behalf?
Well, Your Honor, it's as if I asked you previous also. If you just tell me what the fine is previous, I would have paid the fine. You insist that I come to court because normally if there's a traffic violation, then there's a fine attached to that. I was
Well,
willing
sir,
to pay the
that my recollection is the last time you and I spoke, at first, your wife called in for you and said you couldn't travel and you couldn't take a plane to get back to Kansas because you're.
Oh, I gotta find the clips. I didn't have time. I wanted to throw a little clip in there. She was absolutely insufferable. Thanks again, Zach, for getting this for me. Everybody go over there and check out his channel. Somebody put it in the chat. Law Nerds Unite. He's got good stuff. Let's carry on.
Your back injury, and we continued this for a period of time. And then the last time, I found out you were lying there beside her in bed, and you said what you did, that you couldn't fly or travel. And so I said, well, do you want to proceed? And you said you were under too much pain pills,
yes.
and that you didn't know what you were doing. And
Well, I don't
so
mean
no,
to interrupt you, but I was speaking as August 13th when I came to court. In August 13th, you had me on video. And matter of fact, I was actually being confined in Springwood County, and I asked for a fine.
Well, the bottom line, I'm not gonna go back over your case either, but the reason we didn't take any pleas last hearing, there were several reasons, but one of which was you said you didn't know what you were doing because you were on pain pills and had been apparently for a couple of months. So, all right, in any event, you're set for bench trial, and you're not here today, and you're going to be in custody. Do you have any idea how long?
No, I do not. That's why I was asking if there's a fine attached to the offense. Can I just pay the fine and move on from it? Because I'm
We have misdemeanors involved. My officers are here. I'd renew my motion to issue a bench warrant since he's not here and ready to proceed. We can't even see him, let alone have our officers identify him. Therefore, he's not in a manner ready to proceed. I have two officers here, Cordell and Andrews, who have been patiently waiting. Not that the delay today has been his fault in regards to the earlier docket, but he's not here. He's not ready to proceed. I'd ask for a bench warrant, no bond hold.
Oh, Paul, shut up and stop making sense.
All right, Your Honor, I can proceed on the phone.
Well, no, I can't.
Right now.
I can't, sir, I can't for the very reasons that counsel just said. I don't even know for a fact I'm talking to Danny Johnson. So, all right, at this point, I am issuing the bond forfeiture, the bench warrant, and a no bond hold. So when you get through with whatever you're going through with the military and the court martial, then we can make arrangements to get you and bring you back here and take care of the motions you filed.
Your Honor, I guess because I was thinking the $1,000 bond that I paid, that could go towards the fines.
All right, Mr.
If you do a forfeiture, then I lose $1,000. It's my intent to be in court.
Well, if you want to get an attorney, you can hire an attorney. If you cannot afford an attorney, you can apply for court-ordered or court-appointed attorney. But until then, bond forfeiture, bench warrant, no bond hold, and we're going to be in recess on both your cases today. So thank you, sir. We'll be in recess. You may go.
All right, we're going back on the record.
Indeed. Paul has a fantastic beard. I admit it.
And go ahead, counsel.
Yes, Your Honor, this is Sophia Arnold, present here today with Vanika Arrington. I'd just like to first state that there are some mental health concerns, but they do not rise to the level of competency that I wanted the court to note. The parties have come to an agreed upon resolution to enter a guilty plea. And after discussing with the defendant her important constitutional rights that she's waiving by doing so, she does so voluntarily, knowingly, and intelligently. And this is a plead guilty in close and giving the defendant 14 days of credit for time served. Thank you.
All right. Ma'am, is your true and correct name Vanika Sherelle Arrington?
Yes, ma'am. I apologize. I didn't know you was still the judge out there. I didn't realize you was going to be on the judge duty for so long, ma'am. I wouldn't have been at your courtroom acting up like that. I remember a couple of times I was out there, I wouldn't have been doing all
Manika,
Okay.
make sure that you protect your
problem.
states.
I'm just gonna talk you through some questions and then you're just gonna give me a lot of yes and no answers, okay? And is your age 37 years old? And you completed 8th grade with some additional education, correct? Yes? Okay. And you're asking the court to accept a plea to one count of obstructing law enforcement officer, is that correct? And upon successful entry of that plea, the city's going to dismiss another charge of resisting, correct? That's your understanding?
Yes.
Okay. Thank you. And you understand that you are waiving significant constitutional rights by pleading guilty. You understand that, correct?
Yes. Did I mention how lovely?
And did you have any questions about your constitutional rights that you're giving up?
No, ma'am.
No. And you understand that there's a plea agreement, but I'm not bound to that. I can impose anything up to the maximum of 364 days in jail and $5,000 in fines if I decide that that's appropriate. You understand?
Damn, that's a lot of money. Yes, I do. How
Okay.
long do I have to work off that $5,000?
Okay, the wildest thing about this is obviously she exactly what was stated in the beginning. She appears to have some mental health issues. However, it doesn't rise to the level that she can't proceed. That's the assessment. I think it's correct. And despite all that, it's handled very well and she does the right thing. That's what's shocking. She's got some stuff she's dealing with, but she's way better than your average soft sit.
Okay, hold on. That's not imposed yet. It's not imposed yet. And you understand that, and your attorney reviewed with you possible immigration and collateral consequences that could result from pleading guilty, correct?
Uh-huh.
And is it your statement on January 6, 2025 in Lakewood, Washington, that you willfully hindered, delayed, and obstructed an officer in the discharge of their duties? Is that your statement?
Yes, ma'am.
And how do you plead to one count of obstructing, guilty or not guilty?
Guilty.
Anyone threaten you, pressure you, coerce you in any way into pleading guilty?
No.
No. Okay, you're doing so of your own free will. All right. And I'll find the plea is knowingly, voluntarily, intelligently entered, that there's adequate factual basis to support the plea, and I'll find you've been advised of the nature of charges and the consequence of the plea. I do find you guilty. You have a right to make a statement prior to your sentencing. You don't have to make a statement, but you have a right to do so. And I will hear from the attorneys, and then I'll hear from you if you have any statement you want to make. And it looks like the city's uploaded order for dismissal on all the charges regarding 25L00046.
Yes, Your Honor. Given the guilty plea, the city has a motion to dismiss case number ending in 046 with prejudice. Additionally, the city does have a motion to dismiss the resisting arrest charge in case ending in 139, and that is also with prejudice per global resolution.
All right. And is this 12 months jurisdiction or impose and close?
Impose and close, Your Honor.
Okay. And 15 days credit or 14 days credit?
14 days credit is what the parties calculated, I believe.
Okay. All right. Go ahead, Ms. Arnold.
Yes, Your Honor. This is, so that.
I watched a little bit more of this call. That both of these attorneys and this judge are absolutely excellent and professional. It's not very fun in that sense, but all three of them are doing it right, and they arrive at a good result under adverse circumstances.
Was on the dismissal. Are we going into the sentencing now?
I'm sorry. Yes, I granted the motion to dismiss, and then I'll
Okay.
hear any comment on the sentencing on 25L139.
Thank you, Your Honor. This is a negotiated and agreed upon recommendation between the parties based on the facts of the case and the amount of time spent in custody, and on that, I would ask that the court follow the recommendation of the parties.
Okay. Now, Ms. Arnold, I'll hear from you.
Yes, Your Honor, for the same reasons outlined by Ms. Pace, the defense requests that the court follow the agreed upon recommendation. Thank you.
All right. And Ms. Arrington, did you want to make any additional statement than what your
No.
attorney said?
I
Okay.
just have one question.
Okay. Thank you.
For my financial aid, is it?
All right. And Ms. Arnold, any record you can make in regards to financial ability to pay?
IG or get it to Iris over on Discord.
Yes, Miss Arrington is currently unemployed, and I'm not aware of her seeking employment. I believe she might be attending classes still. That's all I have.
You weigh classes.
Okay. You do your classes. Okay.
Yeah.
I will follow the recommendation, impose 364, suspend 350, give you credit for the 14 days served. I'm going to suspend all the fines and costs. I'm not going to have you pay any additional money. So you're going to be released today. Your case is going to be closed as I'm making a finding of indigency. And any questions about what happened here today?
Oh, no.
Okay.
It's looking so nice still.
Pardon me?
Oh.
And I just wanted to make sure that I didn't have to pay no more.
Okay. All right. Anything further from either of the attorneys?
No, Your Honor.
All right. You're going to receive your paperwork and be released today, ma'am. Good luck.
Thank you so much.
Take care of
Thank you.
yourself, Anika. You're done. You can go ahead and let the officer. Yep.
All right.
Sycamore Meadows versus Kayla Key.
Okay, this is a case I did recently where it's frustrating, you'll see, but it's also entertaining. This is one where a tenant claimed that her cat set fire to the apartment and then just wants to leave her stuff there indefinitely. It's really a frustrating case.
Again, Carrie Zim, Jill Bauer on behalf of Ms. Peace, also present.
All right.
Judge, I know that last time I wasn't here, I got an email from opposing counsel regarding a stipulated order. I sent her a revised stipulated order as to what my client would be willing to agree to, meaning to give Ms. P sometime a date where she can get everything out of the unit and she can take anybody that she needs to take with. We're just asking that they wear appropriate face coverings because of the situation. I wasn't here. I heard through the grapevine of what happened. I just want the court to be aware it's about insurance bids. I mean, realistically, insurance bids and contractor bids and making sure that we have the appropriate people in the unit. All of the things need.
Ma'am, you didn't say the cat jumped on his wiener, did you?
It's soot filled. There's a wall that needs to come down. Am I correct? There's a whole wall that actually needs to be replaced. So it's not something where council wanted Ms. P to be able to leave items upstairs. That's a problem because the smell is going to stay. You know all of the things I'm going to say to you. And so I really just need all of her stuff out and then they can do what they can do. And that's where I'm at. That's what I can agree to at this time. And I sent that order over to opposing counsel for review and they can pick a day.
Well, Your Honor, if they're willing to rehouse her, she would have a place to remove her belongings too. But she's living in her car right now.
Judge, I don't think that's quite accurate because my client's actually seen her with her grandma, who's also in Sycamore Meadows. So I could be wrong, but I believe that that's where they've seen her living.
I could be wrong, but I'm not.
And residing. At this time, Judge, I don't have the authorization to agree to rehouse her, and I don't think that my client's willing to do that either from what I've been told at this point. So I'm willing to give her the time that she needs to get her stuff out of there so they can get in the unit and do what they need to do.
And we believe that they should be rehousing her. So we'd ask the court to.
But she's not in the unit. So I guess I'm unclear as to why you're holding the unit hostage.
Well, we're not really holding.
Put it bluntly. I mean, because that's what you're doing. I mean, they can't, if her things are in there, they can't do anything. And so I don't know who that benefits.
Well, Your Honor, I was not aware that it seemed to me that the damage was just in the kitchen and that there wouldn't be any work being done upstairs. So that's why I thought she could leave her large items upstairs because she has nowhere else to put them right now. If she was rehoused, she would have a place to put them. That's what I was thinking. I did not have the information that a wall needed to be replaced. That would make it untenable to store things on the second floor.
Okay. So now we are aware that that's the case. So
This is so frustrating to me. Again, yes, for all you people, I'm biased. I've been a landlord and I've dealt with this crap and it's frustrating as hell. I don't see, as a matter of law, how they have a duty to rehouse her. But they might. Under some ridiculous law. Who knows? But I don't see where that would be the case. But she wants to keep her stuff there and she doesn't have another place to put it. That's it. I can't prove this, but the facts appear to me that she's at fault for a fire in the place. And now she's dumping on them as if it's their fault. They were not in control of the premises when the fire started. You'll see. If you have any heart at all, you're going to feel sorry for the landlord coming up here. But everyone assumes that the landlord is a billionaire with a monocle. And it's just not the way the world works. It's getting that way because they've run everybody out of it. So the only people who can afford to be landlords are, BlackRock. And that's not good for the world, but okay.
what's defendant's position now? Because whether she's rehoused or not, you can't just hold this unit. I mean, I can issue an order that she has to remove her items, or she's at a certain date they're abandoned, and then they can remove them.
Well, I just heard with you that the second floor, so can I ask her if she has a place to move the larger items? Your Honor, Ms. P has items in the unit that she wants to remove, but she's willing to not take the larger items because she has nowhere to store them, but she just wants the court to be clear that she's not surrendering her right to the unit. She's just removing her things so that repairs can begin. That's what she's concerned about.
At this point, I think I've said it already twice now. My client's not willing to rehouse her. I don't, at this point, I just need her to get the stuff out.
I like this attorney. She's a skosh obnoxious, but it's required under the circumstance. She's kind of getting under Judge Simpson's skin, but he kind of appreciates where she's coming from at the same time.
Oh, so that we can get done what we need to get done. This isn't the first fire that took place in this unit. This is the second fire. So there's problems there, but I think before the court today is what we've discussed about removing the items. And so that's where I'm at.
The order that was sent over regarding removal, what was the date?
I just need her to pick a date. And so that the order says that within the next week, she'll pick a date and she'll be able to go on that date and bring individuals with her. Can I see the?
That's my order.
Oh, okay, Judge, I sent it to her. I thought she.
Okay.
It was one paragraph, Judge, and I'll read it to you. Defendant shall be provided a full day within the next week to go through her belongings and remove any and all belongings from the unit. Defendant shall be allowed to bring people with her to assist her. Defendant and anyone going into the unit shall wear protective clothing and mask while in the unit. So order. And if she wants to pick a date now, I can revise it and put the date and the time she'll be able to be there.
Give me a date.
Okay. No. Actually, the landlord you're really going to feel sorry for is the next landlord with the crazy pink chair. Woman, man, whatever. I don't know. I don't know what the pronoun is.
She needs to talk to find out who can help her, but she will pick a date.
Okay.
7th of February, so within the next week.
Okay, so here's what I'm gonna do. I'm not this way. Can't pick a date, I'll pick a date.
Okay.
It's February 6th.
Thank you, Judge.
Thank you, Judge.
So put that in the order, I'll sign the order, and then what do I need to do? Adjourn this case out to deal with the.
I have 2 other things that I want to put on.
Sure.
I'd like to add an explicit sentence to the order that clarifies that she's not giving up her right to be housed by emptying out the unit.
Again, this presumes she has a right to be housed, which she may or may not. I'm not weighing in on that, but I don't see where she does.
Well, if the case continues, of course she's not. She's
Okay.
challenged. I don't know why that needs. to
Okay,
be
I
there,
just
but
want that to be part of.
Otherwise, she'd get her stuff out and we're done, but obviously we're not.
Okay.
I'll
The
be
other.
handling this when I get Social Security, apparently. Go ahead.
Okay. I think that the stove should be preserved for examination, since that's the key item about how the fire started.
Stove should be preserved.
And we'd like.
Is the cat gonna testify? I'm sorry. I thought I'd asked.
Your Judge, there's pictures of the stove and with the, I think they're attached to, there's actually pictures and
I don't know if her attorney's smart here. The insurance company, generally speaking, would come in here and look for arson, which is hard to show. But that's certainly a possibility.
in the fire report with showing that the stove was actually on, that the knob was on to turn. So I don't know what.
Yeah, I know, but the issue is whether or not a human being turned it on.
I don't know what the issue is, Judge. I understand very, very clear my issue.
I'm not sure how we're gonna resolve that, but
I'm not either,
I'd
but
like an opportunity to see if I can find someone who might be able to weigh in on that.
I don't know how
is
this.
cat still available? I mean, I just asked you a question because. Do you still have the cat? Okay.
Judge, I don't know how she wants me to preserve the stove. I have no way of preserving a stove. So
If she had a dime to her name, there would be a counterclaim for negligence for her starting a fire in the unit. The only reason why we're not wasting our time with that is she could never pay a judgment in a billion years. That's the truth.
unless Miss.
Well, I would imagine that Sycamore Meadows has some storage. I mean, I get the request because somebody's going to have to show me how this.
There's actually a statement in the report from the fire chief that Miss P said that when she walked in and saw the smoke, she heard the clicking of the stove and then walked back out as well. So I don't know how preserving the stove is going to change any of the evidence that's out there, but.
Are you want the stove preserved for what purpose? To determine whether or not there's
It could
some.
be started by an animal. I mean, that's what they put in their motion that I got yesterday.
But
Is
that's
that-
what was in I didn't put that in the
But
motion.
that was a statement, I think, by your client
But-
to the fire.
But she recorded the conversation with the fire department. That is not what she said. So the fire report is not accurate.
Okay, well, to make it fair, you guys are gonna have to find some place to store the stove.
You prefer that I do it on
The stove,
screen?
prepare an order, gotta preserve the stove as well
If my
as,
client has no place to put it, what would you like me to do?
I poured a
Does
cocktail.
Miss Bauer want to find somewhere to preserve it? Judge, because my client doesn't have storage. If they, I mean,
can you guys work out where to store it? I mean, because obviously somebody's gonna have to pay to have it. Or
why doesn't
what do
she?
you want to do to this stove? You want somebody to go and tell you whether or not this stove can be turned on by an animal, right?
I'm sorry, Your
So-
Honor, could you repeat that?
I know, Miss Lee was all
This gets kind of fun right here.
in your ear. So when would you get the person out?
I'll start working on it immediately. Maybe the stove could be moved to the basement since there's not going to be any work done in the basement.
Well, I don't know that. I mean, I'm not the contractor, so I don't know whether or not it's.
I mean, if
Generally speaking, if this was between two reasonable parties, a judge would say, okay, you've got maybe a week or two to get somebody out there to inspect it, and then it's done. That's it.
Okay, so I'm going to be serious about this for a moment. The stove needs to be put in some secure location. All right. You're just going to have to, plaintiff is going to have to figure that out.
that's fine, Judge. I'll figure it out.
Okay.
And then the last thing, Your Honor, is I finally got
Kiddies don't play fair. You heard it here first.
paperwork for the case this week. I'd like to file an answer on behalf of Ms. P. I need time to file an answer to the motion that I got yesterday, and then possibly draft my own motion for summary disposition. So I need time for those things with permission of the court.
How much time are you going to need?
I would like 3 weeks. I don't know if the court would give me 3 weeks or not, because I still have a FOIA request that I'm going to be picking up today that seems to be pretty lengthy.
Judge, we're before you on the 18th of February. You can stick us on that date. You're okay with that?
Probably not, but
Okay.
I mean, I will. But here's what I'm going to do. I'm not giving you 3 weeks. You need to file it by the 14th.
Okay. Thank you, Your Honor.
And then I will adjourn this matter out. We can put you on the 18th,
Okay. Thank
and
you.
then we'll figure out where we're going. February 18th, 2024, 9 a.m. That's in person. You prepare the order regarding preservation, and you prepare the other order, and then I'll sign it. Thank you. I do also want a picture of the cat's front paws.
The things on top of the stove don't need to be preserved. You just want the stove put in a location in the basement or something
Yes,
like that.
that's-
I can get rid of all of this, correct? Because I'm not gonna be able, the
Yeah.
problem with preserving everything that's burnt on the stove is the same problem with all of the stuff.
I don't
in-
think we have pictures of that. I think we're just interested in the mechanics of the stove being able to be examined. So that's fine.
Okay, thank you,
Okay.
Judge.
And I want pictures of the cat's front paws extended as well as the rear paws, not that those are as important for me.
Okay.
Thank you.
Sycamore Meadows versus
I wonder if they dusted for paw prints.
Derek Hall.
Here it is, Andy, now you have to play.
Wow. There you are. Oh, look, it's my baby. It's my baby. His name is Nut. That's his butthole.
Court calls the case, the people are Jared Lepic versus Andrew Elliott.
All right, here we have another cat. That's all Zach's doing there. I think he hunted down something from whatever. The defendant here is a TikTok influencer and obnoxious pink chair owner. You're gonna feel sorry for the landlord here.
Hello, Your Honor. I'm Jordan Lepic. I'm also on this case. Jared Lepic,
Yes.
unfortunately, was diagnosed with influenza A this morning, so he has his Zoom going and can mic in if need be, but he's got very little of a voice box at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Travicia, is it Burrell?
Traversia Borelli.
Okay, sorry.
That's
All
all
right. Okay, what are we doing on this case?
Last week, sir, you had asked that they be out of the house before the hearing today.
Frankly, I think the ears headphones are borderline contempt, but you know, whatever. I'm an old dinosaur.
And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I
if
don't
may.
know that I'm necessarily going to need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am.
You are?
Yes, I am. We
Okay.
owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor,
5,000.
monthly rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the city.
Okay, so here's the thing. Is she right about, she just listed off, I think, $4,000 of late fees that they paid?
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir.
So can I.
All right.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
Okay, look, folks. Oh, ma'am.
Yes.
Here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff
You're
is still
already out.
Right.
You're
they're in
And
the
they
pro-
have surrendered the
it's in the
keys?
pro- yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or two, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor,
folks.
Your
You
Honor, I'm
asked,
in my house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've
No.
just been sitting in my house, sir.
This is incorrect.
okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not,
Sorry.
pardon?
There are still people at the house. One of them had a residence established there apparently. They're still at the house, and unfortunately our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there
Ms.
is.
Burrell, are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just
So
using
here's
my
what I'm
phone
going
to
to
do
do.
this.
Possession to the premises has been surrendered. Ma'am, as of given everything that I'm hearing, your management contract expires what, at midnight tonight? Is that the deal, or?
Yeah, yes. And we can't afford to pay
All
a
right.
property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in North Carolina, right?
Yes, sir. But I will have to make a
Okay.
trip up to North Carolina to assess anything left.
I know. I'm just, I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk, and then I'll just go back and then come back out. Because either you're going to listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3:00 today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys, they've given you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises
Honor.
will be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day.
Okay.
Enough.
So if I I was just gonna set this for a trial. So I can set a trial date, but I'm gonna need the parties in person because apparently there's gonna be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March the 4th? The 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. The best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
And one more question. Will Mr. Lepic have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear via Zoom.
Thank you. And as far as
so that he's present, but you will have to be here in person.
Understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I got to do.
Okay. Thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same. Okay. I will give you the same opportunities that I give the other side in fairness. So you may appear, but he would have to be available via Zoom.
Okay. Thank you so much.
Thank you.
Thank you.
Well, there you have it. Updates on 3 cases. The soft sit with the insufferable wife. This crazy TikTok influencer with the bright pink chair. And who else? Who else do we have on there? I can't remember the third now. Oh, and the cat who started the fire. Fire cat. Oh, fire cat. Thanks again, Zach. Thanks again, Lokificent's Lair. It's time for a big and raid. That's a good idea. I'm gonna send y'all over there. Behave yourselves. You know I'm not bailing you out.